Greetings. Before watching this video, I highly recommend watching the testimonial videos that was included on the flyer or the link that you received this video link to. If you are watching this, it means that you are a member of your law school's criminal law or trial organization, and you're trying to decide what to do for the summer. While you probably have not chosen what path you're going to take after law school, the fact that you've shown interest in criminal law or trial means that in the back of your mind, you are thinking about litigation, trial life, becoming a creature of the court. Now, litigation runs the gambit. You could be a criminal defense attorney or a prosecutor. You could become a personal injury attorney and put up some billboards, or civil defense up in the large corporate buildings. You could decide to do corporate litigation, which can sometimes end up in trial, or perhaps in-house counsel for a company that sometimes handles litigation in-house. Regardless of what path of litigation you're thinking about or end up in, before you can even think about choosing a summer internship, there are several things that you desperately need to understand about the industry and litigation itself. Making decisions without being aware of these dynamics can set back your clock by years and even set you on a path where you have permanent blind spots that are extremely difficult later to identify and remove. Now, the first thing you need to understand are the basic ingredients needed to become a good litigator. You need training, you need trial exposure, and you need smarts. Now, if you watch Law and Order, like many people, you may think that all you need is smarts, creativity, and drive. Randy McGinn, who's a powerful and extremely successful high verdict plaintiff attorney, wrote in her book, Changing Laws, Saving Lives, that for every hour you spend in the courtroom, you spend 100 hours outside of it preparing. Folks who go into litigation relying on their smarts end up painfully reinventing the wheel in some areas and never developing the wheel in others. They do experience some success, but also much failure. And the problem is they never really know why that failure happens. Instead, many of them blame those failures on the facts of the case or the jury pool or anything other than their own blind spots. Now, there's two major schools of trial training. There's criminal and civil, with civil mainly being personal injury, medical malpractice, that sort of thing. Now, the thing is that in civil cases, there's often millions or multi-millions of dollars at stake, which means there are people trying to get those multi-millions and people trying to keep from losing them. They have an insane pressure and incentive to get that money or hold on to that money. And consequently, guess where all the super creative research and trial strategy goes? That's right, civil plaintiff and to a degree civil defense. The level of training on niche issues like jury selection, strategy building, and even finding the story within a case is insane. And while you can go to Amazon and buy trial strategy books, the top shelf stuff is extremely expensive, costing thousands for a weekend single seminar, and is not widely publicized. Now, in spite of all the money being poured into getting good in civil litigation training, one area that criminal law has everyone beat is in cross-examination. And that's because for the defense attorney, cross-examination is usually the most important asset. You often have to prove the majority of your case through witnesses belonging to the opposite party. And on top of it, in criminal cases, you do not have the discovery luxuries of the civil bar. There's no request for admissions, no interrogatories, no production of documents. There's no depositions where you can get sworn testimony for hours to kind of practice crossing your actual witness. In criminal law, you are forced to develop the muscles of adaptation and learn how to swoop down on an opponent's mistakes like a hawk. So while the civil bar shines in its trial training and research, the criminal bar, defense bar shines in its cross-examination tactics and capitalizing on the moving parts of trial. Now, given this, the would-be master litigator has some hard obstacles to overcome. First, you need to get access to this top-shelf training that the civil bar has, and you need it early, so that your trial experiences are not spent developing bad habits or learning painfully slowly through the school of hard knocks. What you want is to have learned these strategies and techniques so your time is spent mastering them, adjusting them to your own personal style, and even beginning to develop your own inventions. Now, this creates a new problem: how and when to get this training. Assuming you knew where the training was and had the money for it, you're not going to be doing that during law school. It's just not practical. It's too much. You're going to have to get it after law school. But the second problem is that this training is hidden in a form of multiple treatises and trial colleges. So let's talk about the treatises for a second. We're not talking about academia's opinion on trial strategy, but what some of the lions of the industry have taken the time to write because they've been doing it. The treatises require much time to read, which you would be doing in addition to whatever work your profession demands when you become a lawyer. Also, the treatises explain strategies, but they do not give you the opportunity to practice them or get feedback on your attempts to practice them. You do not have anyone helping you ensure that you are applying what you've learned correctly or effectively to your own cases. And again, we are talking about quite a lot of material, easily over a dozen treatises just to get the basics of trial strategy. Now, let's talk about the training alternatives you have. When you become a lawyer, you're going to find that most continuing legal education comes in the form of a 1 or maybe a 2 day seminar, because it's really hard to get a practicing attorney to be available for more than that. However, there are some programs available that are more in depth. The state bar usually offers an overview training of trial that is usually more of an overview of trial procedure. In the criminal defense world, the premier initial training is the Bill Daniels Trial Program. That lasts a whole week. Second to that is probably the National Criminal Defense College. That lasts 2 whole weeks. And then there's Trial Lawyers College. This is not necessarily criminal. This Trial Lawyers College that was created by Jerry Spence. That lasts a whole 3 weeks. And then there's programs like Keenan Edge College, which takes months of training broken into multiple trainings that cost, 4 figures a pop. But without fail, these programs try to cram as much material as they can because it is simply not practical for most practicing attorneys to disappear for a week or 2 weeks, let alone three. And because so much is being given in such a short time, these trainings are more of an intense exposure to concepts with some opportunity for asking questions. Many of them have some role playing, but due to the time constraint and the amount of other participants, again, you can stick your feet in the pool, but you never really go swimming. To use an analogy, most trial colleges are like trying to take a huge amount of vitamins at one time. There just isn't enough time to give it all to you, and what cannot be absorbed into the system, it just gets wasted. But let's assume, for the sake of argument, that you make the money investment to get access to all this training, and you bite the bullet and you allocate vacation time to 1 or 2 trial colleges. You still have another major obstacle, which is practice. Becoming exposed to strategies and even role playing is not the same as understanding, and it's a far cry from being battle ready to use them. You need practice to use these skills over and over to become competent. Now, while most of the major training investment is in the civil plaintiff realm, that is probably the worst place to get trial experience. First, most cases settle, leaving a plaintiff attorney doing mostly depositions and battles by briefs, not by trials. And second, with maybe the exception of mega firms like Morgan and Morgan, plaintiff firms are not major recruiters of new attorneys. In fact, the majority of these trial colleges are usually attended by the senior attorneys of these plaintiff firms, or rarely by the junior attorney who could take what they learned and start their own firm, right? The civil defense side is unfortunately not that much better. Civil defense firms are paid by, they're paid by insurance companies under extremely lucrative contracts. Since they tend to operate as a corporate model that capitalizes on the old model of high billing while using lower cost associates to do it. Civil defense firms employ new attorneys to handle the grunt work of research and memos and brief writing and low level depositions, not trial. Trials for the big guys up the ladder. The training is provided, but only as you move up the corporate ladder and not before. And frankly, many civil defense firms often hire ex public defenders who already have significant trial experience. And you still don't get that precious trial experience because still most cases settle in civil litigation. So backing up a bit, how do you get the train? How do you get on the train? Well, yes, there's an internship, but there was a step before the internship. Okay, it's important so you know what exactly is in the internship. Because public defenders are often given a crushing caseload, making it practically impossible to learn trial practice other than by trial by error with real lives at stake. We pioneered a training system designed for a new public defender with zero training or experience. The goal was to turn them into trial monsters in record time with a comprehensive understanding of the law and procedures of their field. It consisted of a 10-week training program that we call the IV drip, kind of like an IV that you have in a hospital. It's designed to turn fresh law school graduates into monsters. Now, the training method is a synthesis of top shelf plaintiff trial tactics with a heavy emphasis on cross examination and case theory development. The program contains 3 coats of paint exposure to new material, including a facilitator who clarifies and synthesizes the material so that it can be immediately applied to actual trial-bound cases. Now, while the material is indeed heavy, it is spread out at a pace that can actually be internalized and applied, very similar to an IV at a hospital, as opposed to some huge giant syringe that trial colleges kind of represent. And in addition, the attorney undergoes, or the attorneys going through this training undergoes repetitive dojos, which are hypothetical practices to ensure that the techniques are baked in and not just merely understood intellectually. And in addition to all of that, the attorney is taken through the state case law of the majority of the criminal charges and criminal procedures in that jurisdiction, again, using an IV drip pace. At an early stage in the training, we found that the new lawyers going through this process found themselves pointing out errors that paid attorneys who clearly never learned this material were making in court. But by the end of the training, the attorney knows how to work up the most serious of felony cases, craft complex cross-examination, integrate theories, themes, and integrate a host of other tools into their cases, channeling all these things into jury selection, openings, and closings. This process resulted in attorneys in their first year first chairing serious violent felony trials and being in a place where in every court hearing became an opportunity to refine their skills, not make up the wheel, reinvent the wheel. Now, the problem is that, in order to do this, we still had to bite the bullet of 10 weeks for this training after hiring someone. So we made a decision. Why not instead train law students with this? In fact, why not create a regimen that would completely train law students so that when they graduate, they're able to hit the ground running? So that's what we did. We created an internship that provides the exact training given to new attorneys to turn them into trial monsters. And by doing this, law students who go through the process are now in a position to do incredible things in an externship and even do trials in a second summer internship. So why does this matter to you? Well, it depends on if you're a 1L or a 2L. Now, if you're a 1L, this probably represents the only time in your professional career when you will be able to safely set aside the time that it takes for this amount of material. To push off doing this means at best you're going to have to take a trial college supervitamin route, or you're going to trickle in training here and there while you're working as you're able. You may not know this, but as a 1L summer intern, most state bars do not allow you to do much in a courtroom in any internship. In fact, most 1L internships involve legal research, legal writing, and perhaps exposure to the industry, but not operating in court itself because you can't. This means that your first summer is the only time that going through this type of training will not be taking away from other major responsibilities or opportunities because, during your second summer, you will most likely want to intern with a potential employer or at a minimum in an area where you are actually able to do things in the court. As a 1L, even if you do not want to go into public defense, the training obtained in this internship will not only give you a career-long advantage, but when marketing yourself for your second summer or employment, you will stand out from your peers regarding what you are capable of, and you'll actually have the skills whether you brag about it or not. Now, if you're a 2L, if you're already a 2L, what we've done for 2Ls is we've combined the best of both worlds by integrating a maximum court exposure program that runs side by side with the IV drip training regimen. By reducing some of the dojo sessions that the 1Ls would be doing, you're launched into active client management, client interviews, negotiations with prosecutors, and actual court activities such as announcements, pleas, and hearings. Whereas most internships have the goal of exposure, right? Usually through shadowing an attorney, watching what they do, and contributing on projects. This internship systemically trains and integrates you into court work while being armed with training that, again, is highly difficult and expensive to gain otherwise. So why offer this level of training and exposure to law students? Well, first, the training for attorneys had to be developed in a way that was scalable, meaning it takes the same effort to train 20 people as it does 2 people. So one reason we offer it is because we can. Second, students that we may end up hiring later, the earlier we get this training into them, the more things they're qualified to do in an externship or a second summer that will give them the experiences that allows them to hit the ground running when we or somebody else hires them. And third, It makes much more sense to train a group of interns because, we can only hire a fraction, leaving the others to perhaps get hired starting at a higher level somewhere else or using this internship to leapfrog into other opportunities. Now, if you're interested, here are a few things that you need to know. First off, the internship itself can be completely virtual as the training and the dojos are done in Zoom. But for our 2Ls who wish to have court practice and our 1Ls who want to have court exposure, there is a significant opportunity for in-person activities, including watching a full trial. The only requirement is that you come hungry and ready for an extremely challenging boot camp experience. The goal, again, is to create a trial monster in a year, not a decade. Now, if you are interested, please just send your notice of interest to the contact that's listed, and upon receipt, you'll be scheduled for an online interview. At that time, you can ask any questions you may have as we both determine if this is a good fit for you. Now, while this summer internship is not for everyone, if your desire is to be a trial lawyer, be sure that you've built into your career path how and when you expect to be trained. This program merely represents one easy way to accomplish that.